I'd like to introduce Flatbush native and first-generation American, Miss Alberthe Bernier. Ms. Bernier has been practicing law for 14 years. Her areas of specialty include estate planning, probate, guardianship, Medicaid planning, and special needs planning. Al is a graduate of St. John's University and St. John's University School of Law. She embarked on her entrepreneurial journey and opened up her own law firm in 2023. Congratulations.
Thank you.
She's a tenacious advocate for the elderly. And aside from being a trailblazer and business owner, Al is also a mom to 2 little ones. So I'm honored to present to you tonight all-around superwoman and powerhouse, Alberthe Bernier.
Thank you. Hi. Thank you, everyone. Thank you so much, Angie, for having me. I am honored to be here, part of your Knowledge Bar series. As an elder care attorney, it's a topic that I'm passionate about. I speak to the community, to different communities, also to attorneys, other professionals, just to educate them on the importance of having a proper estate plan in place and knowing things to look out for and why you should reach out to a lawyer, right? When you're starting to deal with certain things when it comes to the death of a family member, retirement, birth of a new child, those are things that should trigger in your mind. I probably should think about creating an estate plan.
If someone is approaching retirement, how can they prepare for long-term care once the person retires?
Absolutely. If you're approaching retirement, it's just like you're at your job. If you're employed, you're supposed to be meeting with certain departments to start filling out pension paperwork. On your mind should be, I need to reach out to an estate planning attorney. Having an estate plan is in place, it creates a sense of normalcy for your family in the event there's some sort of death or disability on your part. So just like your employer will tell you there's paperwork to fill out for pension collection, you should probably also make an appointment to complete and fill out Social Security papers as you start to edge retirement. Meeting with an estate planning attorney will be key, helpful, and particularly elder law, right? Because there are a lot of lawyers out here who will be able to tell you, I can prepare a will for you, right? They do real estate, they might do personal injury, they may also do other types of general practice law. But in my experience, meeting with an elder care attorney, they're gonna know the right questions to ask you to ensure that your estate plan is in place. For example, one question that I ask is, do you have any children? How do you get along with your children? How do your children get along? Right? Like, because these are the people most likely you're going to be picking as an agent under your estate planning documents, your power of attorney, healthcare proxy, your will, your trust. And if these adult children don't get along, that's going to be a key trigger for me to tell you, look, if they don't get along, we might have to look at other people to be a key person for you on your team, or maybe just one instead of both. So certain questions are important when it comes to elder law planning to ensure that the estate plan is appropriate and it works for you. So to some, if you are approaching retirement, one of the things you definitely should do is reach out to an estate planning attorney. And a lot of the times now, the estate planning attorneys are offering consultations that are complimentary. They're over Zoom. And all you got to do is say, they'll ask you questions about, hey, do you have a will? Do you have a power of attorney? And they will explain what these documents are and why they are important. If you have children, are they married? How's the marriage? That's a question that I ask. If there's trouble in the marriage, if there are bad spending habits amongst the children, I ask these questions because this is how I will tell you we need to create a trust. If we want to stretch out an inheritance, we need to create a trust so that someone who has bad spending habits doesn't have access to a voluminous amount of money at an inappropriate time in their lives. So retirement planning, when you're about to collect pensions and you're filling out beneficiary designations, on your mind should also be meeting with an elder law estate planning attorney.
You mentioned a term, power of attorney. What is a power of attorney and why is that important?
Great question, Angie. A power of attorney is a legal document. Okay, I say it's a legal document because it carries a lot of weight, right? And you shouldn't just print something out online and say, this is my power of attorney, and you sign it. No, here in New York State, to have an appropriate power of attorney that works for you, there are many areas on that document that needs to be initialed. There are many points in that document that need to give certain powers to your agent. So a power of attorney is a legal document that you would sign where you appoint someone to make financial decisions on your behalf. What type of financial decisions? To deal with your real estate, to deal with your pension benefit. I don't know how many of you in the audience today are retired or are collecting a pension. And I know for personal experience, my mom, she is a 1199 pensioner as a former healthcare worker. Every single year, there's a form that is sent out to her home that she must sign and have notarized. And what is that form? It's called, I say, Mommy, is that your proof of life letter? It's the letter that you have to submit on a timely fashion so that your pensioner and provider knows that you're alive and your benefit continues. So we're living in a state where it's extremely high, right, to meet your ends, make ends meet. So to have an interruption in your monthly pension could be disastrous. So if you were to become disabled or you have some hand difficulties, I just had met with a client who has recently left rehab, and writing has been so difficult for her. Her daughter, by executing a power of attorney, her daughter now can sign on behalf of mom. Mom doesn't have to go through the process of filling out paperwork. Mom can also file for benefits for her. If there are certain benefits she might be entitled to, disability benefits, the power of attorney agent can handle those financial matters for you.
Can I use a power of attorney, say, if I have a son or daughter in college? Is that something that can be used in that scenario?
The power of attorney also is an appropriate document for our youngsters, or young adults I call it, who are now going off to college. There are key documents that a parent should have their young adult get. And those key documents are power of attorney and definitely a healthcare proxy, as well as the education waiver. What are these forms? What will they do? They will allow the parents now to be able to have access to important information while that child is away at college, such as grades, such as banking, such as helping them make medical decisions. I have a personal story that I can share about that. My sister, in her last year of college, she fell ill. We thought it was a common cold at first, and after 3-4 days, she just got so much more lethargic and went to the hospital. She had meningitis. Meningitis can kill you, all right? And my sister was literally on her deathbed for a week. It was the toughest time in my family's life. I've never prayed so hard, and I'm married and I have 2 kids. And I can tell you to this day, that was such a jarring moment. And my mom and my dad, thankfully, they were able to make medical decisions on her behalf because she was hospitalized. But in certain instances, if you did not have a healthcare proxy, they would not have been able to make medical decisions, communicate with doctors, and order life-saving treatment. So that's why a healthcare proxy is important for my young adults who are going off to college. When my clients call me and we do a review, because that's something that I do with my clients as well in terms of creating an estate plan, I make sure that I keep in touch with them. Every 3 years they can call me, we have a meeting, and I ask them key questions. And if they tell me, oh, my daughter's about to go to college, bring her on in. Before she goes away, come in and we'll have her sign a healthcare proxy and a power of attorney, as well as the education waiver. The education waiver is important because you're 18. 18 here in America means you're an adult. You can make your own decisions. That means when she or he is off at college and it's the end of the school year, or it's the Christmas or November comes around, they're coming back home, and you ask them, what are the grades like? How are the grades? You can't call up the school to say, I want a copy of the transcript. I want to know what the grades are like. No, because that child is an adult. They have to release that information to the parent. Meanwhile, the parent is paying for the tuition. Okay? So the waiver, the power of attorney, and the healthcare proxy are 3 core documents that I do have my clients, young adult children sign before they go off to college.
So now pivoting over to, thinking about retirement and just preparing, what is a living will and why is that important? How can that be used as you're approaching retirement?
So a living will is also known as an end-of-life decision instruction document. So it's not to be confused with a last will and testament, all right? A living will is the document you will sign where you express what your wishes are when it comes to your end-of-life care and treatment. Meaning, if you are in a terminal condition, terminal state, doctors have diagnosed you and indicated that there is no hope for recovery. In that instance, having a living will where you express that I do not want life-saving treatment such as artificial hydration, feeding, CPR. Like in this instance like that, for my elder law clients, they all expressed to me, I can't say all, maybe about 98%, have indicated that they would not want to be kept alive where a machine is breathing for them. They would much rather just be let go peacefully and with maximum pain management. So that's what a living will is, Angie.
Okay.
It's an end-of-life decision instruction document.
Okay. Thank you, Al. And what is a disposition of remains?
A disposition of remains, that document, it will allow you to indicate who you would like to handle your funeral and burial arrangements. It's a document here in New York that is prescribed by the New York State Department of Health. And you have that form, it's signed, it's witnessed by you, and you express, this is who I want to be the person managing the funeral and burial arrangements or cremation. And there's a section in that form that is entitled Special Directions. In the Special Directions section is where my clients tell me, and I have it written in, what their express wishes are. For example, I have one client who was very adamant about cremation. She did not want to be buried. So we wrote that into the form. I had another client who did not want a viewing. She was like, I do not want a viewing. I want there to be a celebration of my life instead of people crying at a viewing for me. I had another client who was very adamant about being donated to science. And she had the Alzheimer's Association. She wanted her brain and her spine to be donated to the Alzheimer's Association for scientific research. So we had that written into the form. So that is the beauty of a funeral and burial designation, also known as a disposition of remain form.
So I've heard of such a thing, that say somebody falls ill, right? And, Medicare, Medicaid is covering their treatment, right? And then after, say, that person passes, there's a Medicare lien or Medicaid lien. So how can someone prepare either, or at what point in their life can they prepare to kind of be weary? I don't necessarily want my assets to fall, to any potential Medicare, Medicaid lien. Like, how can they protect themselves from that?
Great question again, Angie. As an elder law attorney, when I meet with my clients and I discuss and ask them what their goals are, if one of their goals is to prepare for long-term care and to have maximum asset protection, then I start discussing trust planning. Okay, the healthier and the younger you are where you can create a plan like this, the better. Long-term care planning means you are trying to prepare for the future in the event you need help with your activities of daily living, dressing, feeding, bathing, or grooming, and you want to stay home and get that help. We are living in an age where people are living much longer. My grandmother died at 100. My grandfather died at 97 in 2019. My grandmother is still living and she celebrated her 90th birthday. So with the advent of modern medication, science, and technology, people are living longer. But the fact is, just because you're living longer, your functionality is not the same, right? So for our elderly population, a good portion of them tell me, look, I want to stay home. I would not want to go into a facility if I can control it. So how do you pay for that care? Having someone come into your home to help you with dressing, feeding, bathing, or grooming, right? You need long-term care insurance. A good number of the population do not have long-term care insurance because it's expensive, right? And the insurance industry, they're now pulling out of the long-term care market because it's so expensive, right? When they were pricing these and having these policies in place in the 70s and the 80s, they didn't know that their seniors are going to live this long, right? So a lot of these policies, they're not being offered, or they are offered, but it is extremely expensive. So now we have to pivot. If you don't have private health insurance to cover the cost of an aide to come and help you at home with activities of daily living, dressing, bathing, feeding, or grooming, if you don't have that type of insurance, we want to get help from the state of New York. How can you get help from the state of New York? It's called the Medicaid program. The Medicaid program can cover the cost of a home health aide to come and help you at home. But if the state is going to help you with those needs, the state says we have a right to get paid back by putting a lien on your home or having a lien on your estate. However, if your home is in a Medicaid Asset Protection Trust, this is a special type of trust which will protect your home from a Medicaid lien from ever being placed on it. The thing is, you have to create this trust and transfer the title of your home to this trust a certain number of years before you need the help. You cannot be at the steps of a nursing home and then look to try to shuffle your assets into this trust and try to ask the state for help. You had to have created this trust 5 years prior to you needing the help. That's called the 5-year look-back period, okay, for long-term care in a facility. And if you're looking to get long-term care help in your home, there is a 2.5-year look-back period that's going to be starting in 2024.
And that ties into with your bank assets.
Yes, this trust is not only for your home, where you can deed your home into the trust. You can actually put other assets into the trust to protect it. So working with your elder care attorney, where you are going to divulge and have a transparent conversation about what your holdings are. Maybe you have a summer condo in Florida and you go back and forth. That the state of New York is going to say, we're not going to help you with long-term care. You need to sell that home in Florida first, and then after you use those proceeds and spend it down on your care, then we'll help you. But if this home, summer home, and your home were placed in a trust, it's as if you don't own it. Even though you get the benefit of being able to live in those homes, and you get the benefit of having those properties by having exclusive right to be there to enjoy the premises, you can have those benefits all while being able to get help from New York State. It's such sad state of affairs when a senior who has worked so hard, and me being a first-generation American, right? I'm from Flatbush, Brooklyn originally, and I know that it was my parents' dream to own a home, and they did achieve that dream being immigrants. They purchased their first home in 1994, and we moved to Queens. We left Brooklyn, and that home for myself, for my parents, and for a lot of other immigrants who came here who have worked hard, represents a massive amount of wealth that they can transfer to the next generation. For it to be lost because of long-term care is sad, knowing that your home can actually be placed in a trust and protected so that that home can be passed on to the next generation for education, for them to purchase their own homes, for them to, continue living the American dream. So that is why elder law estate planning is important, because it also involves asset protection planning.
Now with inflation and, the way the market is now, is it feasible for, somebody who, again, is approaching retirement to solely rely on Social Security benefits, or should they have, additional forms of income set up in some way after they retire?
Absolutely. You're right. With inflation, you go to the supermarket years ago, or even just a year ago, the amount of money it took for you to leave the store with groceries, you're seeing that you're spending a lot more to get the groceries to cover your basic needs. So if someone tells me, look, all I have is Social Security income coming in, if you didn't do proper planning, retirement planning and saving, purchasing maybe annuities and putting money into a 401k, I'm sorry to say, here in the state of New York, if you own a home and maybe you still have a mortgage on it, and you may not be able to stay in your home right? To just cover basic needs. So if a client comes to me and tells me that they're struggling, first off, I say, I'm a lawyer, right? I'm an elder care lawyer. That's the only practice I've ever done for my 14 years. So I can give you advice on estate planning and elder law planning. You're now asking me financial planning questions. But in my 14 years of experience, what I have seen help my elder law clients is a reverse mortgage. Right? Yes, we want to protect the house. Yes, we want this home to be passed on to the next generation. But if you can't make your ends meet and you don't have anyone helping you, then maybe that is your only option. Getting a reverse mortgage to help feed and funnel you with cash and money to help you pay for bills, to buy food, groceries, clothes, and basic sundries and living items. So that is one option. If you have a HELOC, which is a home equity line of credit, that's another thing. You can tap into the equity in your home. So that's the advice that I have given clients, and I connect them with someone who's like a financial planner or a mortgage broker for them to investigate their options. But I do want to give a huge disclaimer. I am an elder law attorney, right? And I do estate planning, but because I'm an elder law attorney and I've worked with seniors for the past 14 years, almost 15, that's what I've seen help my seniors.
Thank you. Say you have somebody who, again, is approaching retirement and their spouse died, before they retired. At the time that they retired, can they claim the Social Security benefits for their spouse who died, or is that is that no longer authorized? Or it's not a thing?
So that's a good question. In terms of being able to collect Social Security benefits based on the death of your spouse, if you're collecting Social Security and let's say your Social Security benefit was lower, right? And your husband or your wife passed away and that person who passed away, they had a higher Social Security benefit, you will be entitled to a bump up to the higher amount. So that is the benefit that you do get when you're in a marital relationship, right? Like you're married, it's documented that you're married.
I know you mentioned several forms to us, like, power of attorney, healthcare proxy, and, now in this day and age, it's very simple and, relatively easy for people to just kind of download these forms online, right, and just take it a do-it-yourself approach. In your experience, do you think that's feasible? Is it something, or should they hire an attorney to have, a full assessment of what's, their assets? I'd love to get your thoughts on that.
And I can speak on it at length. By going online and saying I'm going to do DIY and do it myself, at many times people create more headache and more problems than creating safety, creating certainty, because that's what estate planning is. It's creating certainty. If you're no longer here or you're disabled, wouldn't you want it to be clear what your instructions are? But if you have a document that you've downloaded and you thought that that was your power of attorney, but in the very bottom of the corner it says California power of attorney document, which I've seen happen, right? It's like the adult children come forward, we need to figure out the finances. Mom had a stroke, and I'm like, this isn't a power of attorney. Like, this is a form that you got that was appropriate for a California resident. She's a New York resident. Unfortunately, it created more damage, more, because mom probably thought, oh, I'm set, I'm all right. If something happens, my children or my agent or my sister or my cousin will be able to help me, when in fact that isn't the case. So there are pitfalls when you think you can do it yourself. Something that I commonly tell my clients is, if you have a mechanical issue with your car, do you go to your dentist to fix your car? No, right? Your dentist has a specialty in dentistry, braces, maybe drilling and all of the stuff that is associated with teeth. He or she can't fix your car. Same thing with elder law and estate planning. You don't go to a maritime attorney, right, who has a specialty in dealing with naval contracts and for elder law and estate planning. So another thing that I have seen is where I did a will. I created a will. I thought I had a will, and they came forward. The document wasn't didn't have like certain notarization, certain witnesses. Like there's certain number of witnesses that are required, it's certain number of timeline of when these documents need to be signed. So it's more damage. So imagine you have a will and your will says, look, I have 3 kids, but I want to leave everything to these 2 children because this one child is doing really well for himself, which you're in your right to do, right? A client wants to do that, that's their choice. But if your will is deficient or is defective, now your estate is going to pass pursuant to intestacy law and all 3 children will take. That may not be the worst thing in the world, but that wasn't your wish, right? So if you want your wishes known, you want your wishes adhered to, if you do not want artificial feeding, right? You don't want to be put on a machine to breathe for you. You should have an estate plan that's clear and that is created by an elder law estate planning attorney so that all the T's are crossed and the I's are dotted.
Just said, what is a step up in basis?
A step up in basis is an important tax benefit that your estate and your assets will receive upon your death. For example, if you purchased your home in 1994 for $250,000, today it's probably worth almost $1 million, right? We've seen massive appreciation when it comes to real estate in Queens and Brooklyn and the 5 boroughs. So again, that real estate represents a massive amount of wealth that can be transferred to the next generation. But does that mean because you purchased it for $250,000 that when you pass away, your kids are going to have to pay a huge capital gains tax, right? Because there's been appreciation, a gain. And the federal government, right, says if you have a gain on your wealth, right, we want to collect a percentage of that gain. It's called the capital gains tax. Well, when your beneficiaries inherit real estate or stocks that have appreciated in value, if they inherit it by will or through a trust, they will get a step up in basis, meaning the tax basis from $250 will be stepped up to the date of death value, meaning if you passed away and it was worth $1 million, they are now inheriting a piece of property at a starting tax basis of $1 million. So if they sell it for $1,000,001, they're only paying capital gains taxes on the $100,000 of gain from your date of death. Whereas if you added your kid onto the title, I'm just going to put my daughter on the title. I don't want to deal with probate. I don't want a will. Let's just put my daughter on the deed. Well, not only have you lost your important property tax exemptions, such as the STAR benefit, the senior STAR, which represents a 50% reduction in your property taxes, your kid is also going to lose the step up in basis. So that when they sell that property, that stock, which is now trading at $500 a share and you only bought it for $20, they're going to be paying a huge capital gains tax. So doing things such as adding your children to the title or creating a will or going and downloading documents online. I'm all about YouTube University and educating yourself on Google, but when you're taking the important step of creating an estate plan and actually signing legal documents, consult with a lawyer.
How do you handle if you're here on Social Security, if you're on Medicaid, you have property outside of the U.S. that you want to transfer to your children? How do you handle that?
So the thing is, when there's real estate or there's property or cash or accounts outside of the country, my advice is for you to connect with a lawyer, a barrister, who is licensed and practice law in that country. You can create an estate plan here in the States, but there might be different rules in place. For example, Spain, right? They have forced heirship laws, right? So you may create an estate plan that says, I leave everything to my children, my 3 children, and I don't want to leave anything to my husband, right? Because this was a piece of property in the West Indies that I inherited from my mother, from my father. So I really don't want that to go to my husband. This should really go to my children. I've had clients tell me that. Well, in certain countries, they don't care. Forced heirship means if you're married, not only does your spouse partake in that estate, so will your children. So if you have a certain vision about how your estate is supposed to be transferred at your death, you need to meet with a lawyer if you have property outside of the country. That lawyer has to be licensed over there, okay?
A minimum time for New York State, minimum time of residency for someone to be in order to reap the benefits of Medicaid. For example, you have snowbirds, you have different things. So if my mother's away in a foreign country and she falls ill, we have this trust, we got all the stuff set up, and I want to bring her back. When I bring her back, does Medicaid say, well, it doesn't look like this person's been in New York State in the last, like how for taxes it's 6 months. Is there a minimum time, or it doesn't really matter? You can stay there for 10 years, and I'll bring you back if I need to bring you back.
Great question. There's no minimum residency. If you were here and you're found here for 3 days, if you had gone to your country back, you went back home, but you're a U.S. citizen or you have a green card, a valid resident. If you're back and you're found here in New York, which has happened, I have had clients that said mom went down to Florida, she was on her own. Mom and dad, they were living on their own independently in the home, but then dad fell ill, Alzheimer's, wife was caring for him, and she now basically run her body to the ground taking care of her husband. And now she had lost use of her legs. So the kids were flying down to Florida trying to manage, but it was not too much. The 5 kids have children of their own. They live in New York. What was my advice? Bring them back to New York. We got them back to New York. They stayed with daughter for a couple of days, and then we got them right into a facility, and they're on Medicaid. They're home. We had to do some additional planning for the home, right? If they're in a facility and you didn't put the home in a trust 5 years ago, then we're going to have to do additional things. It's higher level estate planning. But what I can say is, although 100% value of the home wasn't preserved, about 45% of the value of the home was preserved as an inheritance for the next generation.
How often should you update your home? Because if your situation changes, so that you can draft your will so that any change after will be entailed in that will that you have. For example, if you get divorced, remarried, something changed.
So that is why, as part of clients that I work with, I tell them it's important to keep me abreast of the life changes that occur. My clients have the ability to have a meeting with me every 3 years and it's by phone usually, where I'm just going over the documents and saying, okay, well, when we created your estate plan, you put this person in charge, or you appointed this person for medical care. And 6 years later, right? 9 years later, I'm doing this review and it comes up. It's like, you know what? I did appoint my sister to be my medical proxy, but she's starting to have dementia issues or memory loss or cognitive impairment. That's why we need to make a change, right? So it's good that I'm creating a relationship with my clients where I want them to be able to force them to pull out their documents, to take a look at it. Many times people create an estate plan and they put it away and they never look at it. By having a review every couple of years, it forces you to think about your life and what has happened and what has changed. Far too many times do people come in for initial client consultation and I tell them, bring your existing estate plan. And they bring me something that was created when their kids were minors, right? So assets weren't left directly to the kids, or they set up trusts, or I put my sister in charge of the estate and she's no longer appropriate, or the relationship has changed. Or I have new kids. The documents only speak to 2 children, but you have additional kids since that you created those documents. So how often should you be updating your estate plan? Because it's not only your will. You should be looking at your estate plan every 3 to 4 years, taking a peek at it, looking at it, and thinking about what has happened in your life. I tell my clients, even if the 3-year review, even if before that, something happens in your life, retirement, death of a family member, death of your spouse, if there has been adoption, birth of a new child, you've come into money, right? Someone has left you money. Now you have new money that's flooded in your estate. Or we need to talk. pick up the phone, ask for a meeting, ask for a phone conference so we can discuss how this life event affects you.
Thank you so much, Al. Thank you for coming to our community. Thank you for educating us on the topic of elder law and why estate planning and just preparing for, retirement is important. Thank you. I hope this is beneficial to all of you. I truly believe that knowledge is power, and my mission is to educate our communities so they can make informed decisions about their life. So thank you for coming.